Today, we are taking on, well, a pretty huge challenge. It sits right at the very core of civilization itself.
Yeah, we're trying to decode law, justice, and maybe the slightly uncomfortable reasons behind why we as societies decide to punish each other.
Exactly. Our mission today, it's much more than just, reading out definitions.
Right. We want to explore that tension, that pull between the written rules, the things that govern us day to day, and those moral ideals we're always kind of striving towards.
Hmm.
And we've got a really robust stack of sources for you today. They should act as a solid overview, taking us from the basic definitions all the way to, well, some pretty high-stakes philosophy like John Rawls,
Okay.
and then through the practical side like natural justice, and finally landing on those criminal theories that, ultimately dictate things like freedom and punishment.
That tension you mentioned, that feels like the perfect place to kick things off. Law, like you said, it's concrete. You can read it, it's codified, and it's enforced, sometimes quite literally, by the physical force of the state police, military, courts.
Yeah, it has teeth.
But justice, well, it's abstract, isn't it? It's this ideal built on morality, fairness, equality. It feels almost ethereal sometimes.
Absolutely. So the big question is, how do you create a system that's rigid enough to give us stability, but flexible enough to actually serve this flowing, changing ideal of fairness?
It sounds like the ultimate balancing act.
It really is. And I think we need to understand the function of the structure first, the law part, before we can really critique how well it achieves the ideal, the justice part.
It makes sense.
So our conversation today, the hope is, it gives you the language and the context to navigate that very complexity.
Quick, let's start with that concrete structure then. Law. When we talk about the law in its most basic sense, what are we actually discussing?
Well, the sources define law pretty clearly. It's a set of guidelines, principles, specific values, all established by a governing body, like a state or government.
To do what? Exactly.
Essentially to control the actions and lives of the individuals within that state. It's kind of the infrastructure of social control, if you like.
And crucially, these aren't just suggestions, are they?
Not at all. They're backed by state-recognized sanctions. There are consequences for not following them. They are mandates.
And the power dynamics involved here seem really essential. These laws, they're regulated, they're enforced by government authorities.
Right. That includes the judiciary, the courts, obviously, but also the police, sometimes even paramilitary forces. It makes compliance, well, not really optional.
So the state can use physical force if necessary to ensure people follow the law.
That's the underlying reality, yes. And while the specific rules, the actual laws, can differ hugely from place to place.
Yeah, what's legal here might be illegal somewhere else.
Exactly.
Right.
But there's also this important international layer. Things like international conventions, treaties, they impose another level of legal obligation on governments that sign up to them.
Creating this kind of web of governance that goes beyond just local borders.
Precisely. It connects different systems.
So why do we go to all this trouble, this massive, often incredibly complicated system of laws? Our source material really emphasizes that the objective of law is, well, absolutely necessary for civilization, for progress even.
It seems to be. It ensures social norms are maintained. It prevents, or at least aims to prevent, that default state of chaos or constant conflict. It lets communities and diverse groups coexist, ideally.
And maybe most importantly, especially in modern governments, the law acts as a vital check and balance, doesn't it?
Oh, absolutely. It keeps an eye on all three branches, the executive, the legislative, the judicial. The idea is to make sure no single entity, no single person becomes superior to the others.
It sort of institutionalizes accountability.
That's a good way to put it. It tries to build accountability into the system itself.
But I think the most fascinating role of law, maybe beyond just keeping things stable, is its role as a catalyst. It's not just static. It can be a tool for real societal transformation.
It's the mechanism, isn't it? It's how societies can take moral ideas, evolving standards, and forge them into something enforceable, something real.
Can you give an example?
Well, look back through history. Law has been the instrument used to formally dismantle deeply entrenched traditions, things that lasted centuries but were eventually seen as morally wrong by society.
Like what?
Our sources specifically mention the abolition of traditions like caste discrimination, sati pratha in India, child marriage. These weren't just cultural shifts that eventually got written down.
No.
No, often they were legal mandates. Laws were passed that forced social change, often against significant resistance.
That's a really key insight then. Law doesn't just reflect society, it can actively drive it. Okay, now let's pivot. Let's talk about its difficult abstract partner, justice.
Right, justice. It's interesting, the name itself comes from the Latin word jungere,
Which means,
to bind together. And that etymology tells you something important. Justice is seen as the value that unites people in a society, gives everyone an equal stake, a sense of belonging. It's fundamentally tied to morality.
intrinsically linked, you could say?
Exactly. And because it is abstract, defining it precisely has been a challenge for scholars for, well, millennia.
I bet. Any notable attempts?
Blackstone described it quite beautifully, actually.
Right.
He called justice the reservoir from which the notion of right, responsibility, and equity develops. Like, it's the source code for fairness.
The source code, I like that.
And then you have the foundational philosophers, of course. Plato, in the Republic, he saw justice as what was fair and right in both individual acts and state acts, a really comprehensive moral framework.
And Aristotle.
Aristotle focused more on distribution and correction. For him, justice was simply what is fair and equitable in how we apply rules and how we distribute resources.
Okay, so let's try and synthesize this core difference for the listener.
Yeah.
Law. It's the written, codified system enforced by the state. Concrete. Justice.
Yeah.
It's the moral ideal, the aspiration, built on fairness, equality of rights. Abstract. Ethereal, even.
Yeah, and we use the codified system, law, to try and achieve that abstract goal, justice, with varying degrees of success, obviously.
Okay, so if justice is this moral aspiration, Section 2 really dives into how we try to quantify it.
Yeah.
How do we actually make decisions that serve this abstract ideal? And we have to start with the school of thought that really dominated governance for centuries.
Yeah.
Utilitarianism.
Yes, the utilitarian theory of justice, famously championed by Jeremy Bentham. The core idea is, on the surface, quite simple.
Which is?
It says that the main goal of any law, any government action, should be providing maximum justice to the maximum number of people.
Maximum good for the maximum number. Sounds straightforward enough.
It's a system built entirely on majority rule and maximizing the collective well-being.
It does sound good on paper, achieving the greatest good. But how did they actually measure that good? The source mentions something called hedonistic calculus. Sounds a bit clinical.
It is rather clinical. That's where the philosophy tries to become almost mathematical. Hedonistic calculus attempts to figure out public utility by essentially weighing up the likely pleasure or happiness an action will create against the pain or suffering it might cause.
So like a cost-benefit analysis, but for happiness.
Pretty much. The goal is to maximize the net positive outcome, the total pleasure minus the total pain across the whole population.
And this allows decision makers
To justify actions that might cause some harm to a few people if, and this is the key part, if it guarantees a much larger benefit to many others.
And that right there, that's the big vulnerability of the theory, isn't it?
It's the fundamental problem, yes. And it's exactly why John Rawls stepped in. He strongly, vehemently condemned utilitarianism in his masterpiece, A Theory of Justice.
Why so strongly?
Because Rawls saw very clearly that maximizing the total happiness of the majority inevitably allows, even encourages, governments to disregard or even actively violate the rights and wishes of a minority.
If it serves the greater good.
Exactly. For Rawls, any system that sacrifices individuals, even a few, for the happiness of the masses could never, ever be truly just. Justice has to protect everyone.
So what was his alternative? He proposed this revolutionary hypothetical scenario, didn't he? To try and fix this moral gap.
He did. He wanted to force decision makers to create laws that genuinely protect everyone, no matter their position in society. He asks us to imagine a group of people tasked with designing the fundamental structure of society. The laws, the rights, how goods are distributed, the whole setup.
Right, designing the rules from scratch.
But, and this is the genius part, they have to do this under a condition of absolute ignorance about their own place in that society.
Ignorance. How so?
They wouldn't know if they were going to be rich or poor, healthy or sick, talented or maybe struggling. They wouldn't know their race, their gender, their religion, not even which generation they belong to.
Wow, that's radical. This is the famous veil of ignorance, right?
That's it, precisely. It's a brilliant theoretical device because it strips away self-interest. It ensures that the rules can't be influenced by selfish desires.
Because you don't know who you're going to be.
Exactly. It eliminates any kind of bargaining hierarchy. You can't argue for a law that privileges the rich if there's a chance you might wake up poor tomorrow. You can't disadvantage a minority if you might be that minority.
So the motivation changes completely.
It does. Rawls' key insight is that the motivation behind choosing just rules behind the veil isn't necessarily altruism, it's actually radical self-protection.
Explain that.
Behind the veil, Rawls assumes people are rational. Since they don't know where they'll end up in society, the most rational thing to do is to select rules that ensure the worst off people in society do as well as possible.
Why the worst off?
Because you might be one of them. You choose the minimum acceptable standard you'd be willing to live under because you might be forced to live by that minimum. It's about maximizing the minimum position, sometimes called maximin.
So the focus shifts entirely, away from maximizing the total good, like the utilitarians wanted,
and towards maximizing the security and dignity of the most vulnerable citizens.
and this leads to what Rawls called a well-ordered society.
Yes. A society where all members accept the same basic principles of justice, and where the social institutions, the government, the economy, the legal system actively satisfy those principles. And crucially, they advance the good of all members, but especially those at the bottom.
Okay, that's a powerful philosophical alternative. Now, moving from those high ideals, the sources also talk about two very practical dimensions of applying justice day to day: distributive and corrective justice.
Right. These are really about how those big ideals actually manifest in the real world, how justice gets done, so to speak.
Let's start with distributive justice. This seems to focus on outcomes.
It does. It's all about the socially just allocation of stuff, resources, goods, opportunities. It tackles the big questions of how wealth, income, social status, even political influence get portioned out within a community.
Where do we see this in action?
Oh, everywhere. It covers things like affirmative action policies, how decisions are made about recruitment and promotions, especially in public office, admissions to public universities, welfare programs, access to healthcare, public goods. It's all under the umbrella of distributive justice.
It's basically the measure of whether society is allocating its benefits and burdens fairly.
That's a great summary. And historically, ideas about how that distribution should work have varied quite a bit.
Like Aristotle again?
Right. Aristotle, for instance, argued that goods and wealth should be distributed among citizens strictly according to merit. Basically, if you contribute more, you should receive more. A very different model than Rawls, obviously.
Definitely. Now, contrast that with corrective justice. This isn't about the initial distribution, is it?
No, corrective justice isn't concerned with the original outcomes. It's about rectification. It has what the sources call a rectificatory characteristic, meaning it tries to restore the balance, the equilibrium, after an injustice has been inflicted by one person on another. It's about fixing wrongs that have already happened.
So, corrective justice deals with the fairness of the response to a wrong or an injury.
Exactly. If the process works properly, the liability imposed the punishment or remedy rectifies the injustice.
And the responses are tangible things we recognize.
Very tangible. Punishment in criminal cases, making someone return stolen property, ordering someone to pay for damages they caused in a civil case. It's all about trying to restore the balance of rights that was momentarily broken by the wrongful act.
Okay, we've looked at the big philosophical frameworks trying to define and administer justice. But what about the sort of inherent, maybe unwritten rules of fairness that should apply to any legal process,
Right.
regardless of the specific law? This takes us to the critical principles of natural justice.
Yes, natural justice. The concept itself, it's derived from a Roman law phrase, jus natural.
Just natural.
Right. And what's really crucial for you, the listener, to understand is that natural justice is quite unique because it's generally not codified.
Meaning it's not written down in a specific law or constitution?
Exactly. You won't find a Natural Justice Act, typically. It's more closely related to common law traditions and these fundamental moral principles that are just considered universally essential for fair treatment. Think of it as the baseline of fairness.
So where does it come from then, if not statutes?
It's essentially the judicial conscience, institutionalized. Our sources make it clear that the judiciary, the courts, adopted these principles over time precisely to protect the public's rights against arbitrary decisions, especially decisions made by administrative authorities like government departments or agencies.
So they're like a safeguard against unfairness by the state?
That's a perfect way to think about it. They are the bedrock of what we often call due process. They ensure that even powerful state bodies have to adhere to basic fundamental fairness when making decisions that affect people's rights.
In this unwritten code, it's been distilled down into specific rules.
Yes, over centuries of case law, it's generally recognized as having three distinct, really powerful rules. The first, and maybe the most foundational, is nemo judex in causa sua.
Okay, Latin again. What does that translate to?
Quite simply, no one should be a judge in his own case.
That makes sense.
It demands absolute impartiality from the decision maker. The judge, or whoever is deciding, must base their judgment purely on the evidence presented. They can't have any personal stake or bias influencing the outcome.
Bias seems like a slippery concept, though. How do they define it?
Well, the system recognizes that bias can be complex, and the sources actually detail 6 specific types of bias that could invalidate a decision under this rule.
6 types. Okay, let's hear them.
Well, the most obvious one is pecuniary bias. That's where the judge has a direct financial stake in the outcome of the case.
Like owning shares in a company involved in the lawsuit.
Exactly. That's usually an automatic disqualification. But it goes beyond money. There's also personal bias.
Meaning a personal relationship.
Right. Friendship, animosity, family ties, any personal connection to one of the parties that might cloud judgment. Then there's subject matter bias.
Right.
That's where the judge has a strong pre-existing opinion or connection to the issue being litigated, even if they don't know the parties. Maybe they've campaigned on the issue before or have a strong ideological stance.
Okay, that makes sense. What else?
Then we have departmental bias. This one's interesting because it can be quite subtle.
How so?
It's the potential bias a decision maker might have in favor of the administrative unit or government agency they belong to. They might unconsciously favor their own department's position or policy. It's like team loyalty, potentially overriding impartial judgment.
I can see how that could happen. 2 more.
Yes. Policy notion bias, which is similar to subject matter bias, but maybe more about upholding a specific administrative policy, even if it leads to an unfair result in a particular case. And finally, bias on the account of obstinacy.
Obstinacy, being stubborn.
Essentially, yes. It's where a judge or decision maker becomes so fixed on their initial view, perhaps formed early in the proceedings, that they refuse to genuinely consider new evidence or arguments that contradict it. They just dig their heels in.
Wow. These really show how achieving true impartiality is much harder than it sounds.
It requires constant vigilance. Okay, the second major rule of natural justice, maybe the one people are most familiar with, is audi alterum partem.
Another Latin phrase. Translation.
To the other side.
The cornerstone of fairness, surely.
Absolutely. It means that no person can be condemned, punished, or have their rights negatively impacted without being given a full and fair opportunity to be heard.
What does that involve, practically?
Well, it requires several things. Both parties must get adequate notice of the case against them. They need to know what they're accused of. And crucially, they must be given a sufficient opportunity to present their side of the story, their relevant points.
And to challenge the other side's case.
Yes. Usually that includes the right to present evidence, call witnesses, cross-examine the other side's witnesses, and make legal arguments. A fair trial, essentially. If you're penalized without valid reasons given and without that chance to speak and defend yourself, this fundamental principle has been violated.
Okay, and the third rule.
The third rule is essential for accountability. The requirement for a reasoned decision. This is often referred to as needing a speaking order.
A speaking order, what does that mean?
It means the adjudicating body, the court, the tribunal, the administrator must clearly articulate the reasons why they reached their decision. They have to explain their logic, point to the evidence they relied on, and outline the legal principles they applied.
They have to show their work, basically.
Exactly. They must speak their decision into existence, backed by reason, not just issue a blatant outcome.
Why is laying out the reasoning so crucial?
Because that responsibility, the duty to record reasons, acts as a powerful barrier against arbitrary action. It prevents decisions based on whim or prejudice.
How so?
If a judge or an administrative body knows they have to publicly document their thought process, they're much more likely to stick to the actual evidence and the established legal principles. It forces a degree of intellectual honesty.
And it also helps the losing party, right?
Immensely. It makes the whole process transparent. The losing party understands why they lost, and importantly, it provides the necessary groundwork if they want to appeal the decision. You can't really appeal effectively if you don't know the reasons for the original judgment.
Okay, so we've got the ideals of justice. We've got these fundamental rules of fairness like natural justice. Now let's get into the engine room. The actual administration of justice. How this system works. Salmon defined it pretty sharply, didn't he?
He did. He called it the maintenance of right within a political community using the physical force of the state.
It was quite a stark definition. Physical force of the state.
It is, but it's comprehensive. It really covers the entire life cycle of a legal action. From the very beginning, filing cases,
Through the court proceedings themselves.
to the pronouncement of judgments, and then crucially, the execution of those judgments, making sure the court's decision actually happens.
It's arguably the most essential, tangible function of the state, wouldn't you say? Maintaining that order.
Yeah. Many would argue yes. Without it, rights are just theoretical. Now, when we talk about administering justice, we immediately need to make a big distinction
Okay.
between the two main mechanisms society uses, civil justice and criminal justice. They often look at similar actions, similar events, but through fundamentally different lenses.
Okay, let's break those down. Civil justice first. What's its main goal?
The primary object of civil justice is to enforce rights. It's about resolving disputes between individuals or entities.
And the liability, the consequence.
The liability in civil cases is overwhelmingly remedial. It seeks to compensate the injured party or fix the harm that was done, to put things right, essentially.
And the remedies reflect that restorative focus.
Exactly. The outcomes in civil court are things like judgments, ordering someone to pay damages, monetary compensation, orders to pay a debt, injunctions, which are orders to stop doing something.
Or sometimes orders to do something.
Yes, like specific performance of a contract, forcing someone to fulfill their side of a deal. Or orders for the delivery of possession of land. Even things like divorce decrees or restitution of conjugal rights fall under civil justice. It's all about addressing the private wrong and providing a remedy to the person whose rights were violated.
Okay, so that's civil justice, focused on rights and remedies. Now contrast that with criminal justice.
Criminal justice has a very different object. Its primary goal is to punish wrongs, to punish acts that society has deemed harmful, not just to an individual, but to the public order itself.
And the liability here is...
On the whole, it's penal. It seeks to condemn the conduct and impose a cost, a punishment, on the perpetrator for violating society's rules.
So the consequences are fundamentally different from civil remedies.
Completely different. The consequences in criminal law range from, say, a fine, all the way up to probation, community service, incarceration in prison, life imprisonment, or in some jurisdictions, even the death penalty. These are punishments imposed by the state on behalf of society.
Now, here's where it gets a bit nuanced, I think. It's really important for you, the listener, to realize we can't always distinguish these two just by looking at the physical act itself, can we?
No, absolutely not. The material is very clear on this. Some actions are both a civil wrong, what lawyers call a tort, and a crime.
Can you give an example to make that clear?
Sure, think about something like assault. If someone physically attacks another person, that's clearly a crime. The state can prosecute them, potentially leading to jail time or fines. That's criminal justice.
Right.
But the victim of the assault has also suffered harm, injuries, medical bills, maybe lost wages. They can sue the attacker in civil court to recover damages for those losses. That's civil justice.
So the same punch can lead to both a criminal trial and a civil lawsuit.
Exactly. Or think about defamation. Spreading harmful lies about someone can be a crime in some places, but it's almost always a civil wrong, allowing the defamed person to sue for damages to their reputation. The difference lies entirely in the legal consequences sought.
And the different courts and procedures used to seek them. One involves the state prosecuting, the other involves individuals suing each other.
Precisely. State versus individual in criminal law, individual versus individual usually in civil law.
Okay, so once we have this huge functional system of legal justice, both civil and criminal in place, we have to step back and ask, how good is it really? Let's look at the merits first. What are the benefits of having this formal system?
Well, the first absolutely undeniable merit is uniformity and certainty. Legal justice, ideally, provides stability and predictability.
How so?
Because the law is written down or established through precedent, everybody theoretically knows what the rules are, or at least they have the means to find out.
And judges don't just make it up as they go along.
Right. Judges are supposed to decide cases according to that declared law, not based on their own personal feelings or whims on a particular day.
And this certainty is vital, isn't it, for just living our lives?
Absolutely. For economic activity, for personal conduct. Because the law is relatively fixed and predictable, citizens can shape their behavior accordingly. You know the boundaries, you know the likely consequences. It reduces uncertainty.
Okay, uniformity and certainty. What's the second big merit?
The second major merit is impartiality, or at least the aspiration towards it.
How does the system promote impartiality?
Because judges are constrained by those predetermined legal principles we just talked about. They must give decisions according to those rules and principles, and theoretically, they cannot go beyond them just because they like one party more than the other.
So the reliance on fixed rules helps remove personal bias.
That's the idea. It promotes a more objective administration of justice, reducing the risk, again, theoretically, of a judge favoring one side due to emotion, prejudice, or corruption.
Okay, those are significant benefits. But that very rigidity, that reliance on fixed rules, it's also a double-edged sword, isn't it? That brings us to the defects. The first major one being rigidity.
Yes, this is a profound challenge for any legal system. Law, especially law laid down in binding precedents from past cases, may not adjust quickly enough to keep up with the constantly changing needs and values of society.
And this can lead to unfairness.
It absolutely can. It can lead to significant hardship and what feels like real injustice in specific individual cases where the old rule just doesn't seem to fit the modern context or achieve a fair outcome.
And judges often stick to the old rule anyway, right? There's that saying, hard cases should not make bad law.
Exactly. And we need to unpack that saying a little.
Please do. Why would trying to be fair in a hard case lead to bad law?
The thinking is this. If a judge stretches or outright breaks a well-established, generally useful legal principle just to achieve what feels like a morally satisfying outcome in one single, difficult, exceptional case.
They risk messing up the law for everyone else.
Precisely. They risk damaging the overall consistency, predictability, and certainty of that legal principle for potentially millions of future cases where the principle actually works well. So judges often choose to uphold the consistent rule, even if it feels harsh in that one instance, prioritizing systemic stability over individualized justice in that moment. That's where the feeling of rigidity comes from.
Okay, that makes the dilemma clear. What's the next defect, it seems related? Technicalities or formalism?
Yes, formalism. This is the criticism that legal justice sometimes gets bogged down in, well, legal technicalities. It attaches more importance to following the correct procedures and forms than to the actual substance or merits of the issue being decided.
Procedure over substance. Can you give an example?
Sure. Think about strict time limits for filing documents in court. If a lawyer, through a simple mistake, misses a filing deadline by just a few minutes, a case that might have strong merits, a morally just case, could be thrown out entirely.
Just because the paperwork was late?
Exactly. The focus becomes adherence to the procedural ritual rather than finding the truth or achieving a just outcome based on the facts. It can feel incredibly unfair.
And the final defect mentioned is complexity.
Yes. Modern society is just incredibly intricate, isn't it? And the law has to try and regulate all that intricacy.
Technology, finance, global interactions.
Everything. And attempts to simplify or codify the law, which lawmakers are constantly trying to do, often seem to lead almost inevitably to renewed complexity very quickly.
Why is that?
Because as soon as you simplify one area, new situations arise, new technologies develop, people find loopholes, and you need new, more complex rules to address those. It often feels like a never-ending cycle. The more sophisticated the society, the more complex and labyrinthine the law tends to become. It's a constant struggle to keep it understandable and manageable.
Yeah.
So, if legal justice, with all its strengths and weaknesses, ultimately fails to maintain order, or when someone definitively breaks those established rules, the system triggers its ultimate mechanism, especially in criminal law.
Right. And this brings us to the really thorny philosophical questions about why we punish. What's the actual purpose?
Well, the fundamental aims seem pretty clear on the surface. You want to give some form of relief or justice to the aggrieved party, the victim, and you need to maintain law and order in society.
Okay, those are the basics. What about broader objectives?
The sources list several: protecting society by deterring potential offenders, scaring others off, preventing the actual offenders from committing more crimes, trying to eradicate certain evils or maybe even reform criminals, and generally maintaining rules so we can have a relatively crime-free country.
But the theoretical basis for how punishment achieves these goals, that's where the different theories come in, right? There are four main ones discussed.
Exactly. 4 distinct philosophical justifications for why the state inflicts punishment. And they have very different focuses. We begin with the deterrent theory.
Associated with Jeremy Bentham again, right? The utilitarian guy.
The very same. This theory is built squarely on his idea of hedonism, that people are rational actors who seek pleasure and avoid pain.
So how does punishment fit in?
The idea is, if punishment is swift, certain, and severe enough, The potential pain of getting caught and punished will outweigh any pleasure or benefit the person might get from committing the crime.
So it deters them from doing it in the first place.
That's the primary goal. And interestingly, the focus here isn't really on the individual being punished, it's more about the external audience.
Making an example of them.
Precisely, creating fear in other like-minded people by showing them the harsh consequences. It's meant to be a loud, clear, societal warning signal, don't do this, or this will happen to you.
Okay, sounds logical in theory, but how effective is it in practice?
Well, the criticism is pretty substantial. Empirically, it's often proved ineffective in actually checking crime rates long term.
Why not?
Several reasons. Excessive harshness, for example, can sometimes backfire. It might arouse public sympathy for the condemned person, which actually undermines the deterrent message.
And maybe more fundamentally.
More fundamentally, deterrence really breaks down if the punishment isn't perceived as being certain or swift. If people think they probably won't get caught, or that the legal process will drag on for years, the severity of the eventual punishment loses much of its deterrent power.
The source material uses a really powerful and tragic example here, the Nirpaya gang rape case in Delhi.
Yes. In that case, the accused were eventually hanged, the most severe punishment possible under Indian law. A clear attempt at deterrence.
But the intended effect didn't happen.
Sadly, no. The horrific crime of rape continues to occur frequently. What that case tragically illustrates isn't just that deterrence failed in that instance, but that the sheer severity of the punishment couldn't overcome the deeper systemic issues, the lack of certainty of capture, the delays in the justice system that really undermine deterrence in the first place.
And another major criticism is that this theory offers absolutely no chance for the offender to reform, does it? It's purely about prevention through fear.
None whatsoever. It's not interested in rehabilitation. Which leads us directly to the second theory, a much older idea, the retributive theory.
Ah, the famous tit-for-tat philosophy. An eye for an eye, a tooth for a tooth.
Exactly. The core motive here is inflicting a similar amount of pain or harm on the offender as they inflicted on the victim or society. It's about payback, essentially, restoring a perceived cosmic balance.
Is there any justification beyond simple revenge?
Well, proponents argue that every punishment is, to some extent, retributive. It satisfies a deep-seated human need for justice for the wrongdoer to get what they deserve, which helps restore psychological peace to the victim and society.
But this approach is hugely problematic today, isn't it? Mostly on humanitarian grounds.
Yes, it's generally not favored in modern legal systems. Inflicting suffering for its own sake raises serious ethical questions, and philosophically, it's very difficult to justify.
What's the central difficulty? We touched on this earlier.
It's determining the exact proportion. How much pain should be returned? How do you measure the suffering caused by, say, fraud or emotional abuse, and then translate that into an equivalent amount of prison time or financial penalty?
It seems like an impossible calculation.
It really is. It's trying to quantify the unquantifiable. And if society operated purely on this basis, if everyone just sought proportionate revenge for every wrong,
The whole system of natural justice, of due process, would just collapse.
it would descend into chaos. Retribution is fundamentally an emotional response, and justice, as we've been discussing, aims to be a rational, principled application of law.
Okay, moving away from retribution then. The third framework is the preventive theory. This one's sometimes called the disablement theory. It sounds more pragmatic.
It is perhaps the most straightforward and pragmatic of the four.
What's the goal here?
Simple physical prevention. It aims to stop the specific offender from committing future crimes by, essentially, eliminating their capacity to do so, usually by removing them from society.
So this is the logic behind it.
This is the primary justification for punishments like the death penalty or long-term incarceration, particularly life imprisonment without parole. Society protects itself from someone deemed an ongoing threat by physically separating them, disabling them.
It's not really about deterrence or reform then.
Not primarily. While long sentences might also deter or offer chances for reform, the core logic of the preventive theory itself is just incapacitation. Stop this person from harming others again.
And it can apply even within prison.
Yes, the source mentions the practical application in things like solitary confinement. It cites the 1978 Indian case Sunil Batra v. Delhi administration, where the court acknowledged that putting a particularly violent or dangerous prisoner in solitary might be necessary.
Not as punishment, but purely for safety.
Exactly. To prevent them from harming other inmates or staff. The focus is purely on preventing further harm, protecting the immediate community, even if that community is inside prison walls. It's about managing risk.
Okay, that's clear. Finally, we get to the fourth theory. Perhaps the most ethically appealing, but also maybe the most complex in practice, the reformative theory.
Yes, reformative theory centered on rehabilitation. This approach operates on a fundamentally different premise.
Which is?
It's based on the idea that crime isn't always a sign of inherent evil, but sometimes happens accidentally, or due to circumstances, or because the person lacks skills or opportunities. It believes offenders, many of them anyway, deserve a second chance.
To become law-abiding citizens.
Exactly. The focus is on changing the offender's character, habits, or skills so they won't reoffend upon release.
And this is where we see specific institutions and programs developed.
Right. This theory drives the development of facilities aimed at change. Correctional homes, juvenile detention centers that focus on education, reformatories, parole systems, probation services, all designed to provide training, therapy, education, and support.
The material mentions some positive examples in India.
Yes, it cites the initiation of open jails as an example. Following cases like Dharampur v. State of Uttar Pradesh back in 1979, open jails give prisoners more responsibility, allow them to work, gain skills, preparing them for reintegration, specifically aiming to reform, particularly younger offenders.
And the importance of this approach for young people is highlighted too.
Very much so. The Supreme Court in India emphasized this in Musakhan v. State of Maharashtra in 1976. They noted that the reformative system is absolutely vital for juveniles.
Why, particularly juveniles?
To prevent them from becoming hardened, lifelong criminals, to offer them an off-ramp, a chance to turn their lives around before patterns become too ingrained. It recognizes that young people are still developing.
It sounds like the most humane approach. But even the reformative theory faces some pretty harsh criticism, doesn't it?
It does. A major criticism is its perceived limited applicability. Many argue it really only works, or is appropriate, for certain types of offenders, maybe juvenile offenders, first-time offenders, those who committed crimes due to specific circumstances like addiction.
But not for everyone.
Not for hardened repeat criminals or those who've committed particularly heinous violent offenses. For those individuals, many argue, reform is unrealistic or even impossible, and the focus should shift back to prevention or retribution. And there's another, perhaps even more profound, moral challenge.
Which is?
It often feels deeply unjustifiable to the victim of the crime.
How so?
If the entire focus of the system shifts to the comfort, the well-being, the education, the future prospects of the person who caused the harm.
The person who suffered the harm can feel ignored.
Exactly. The victims, the aggrieved party, may feel their suffering, their loss, their need for justice, or even just acknowledgement has been completely diminished or overlooked by the state. The system constantly struggles to balance empathy and support for the perpetrator's potential reform with achieving meaningful justice for the victim. It's a very difficult tightrope to walk.
So we started this deep dive trying to find some structure in that complex relationship between codified law and the abstract ideal of justice.
Yeah, we explored how ideas like Rawls' veil of ignorance try to force rational actors to choose laws that protect the most vulnerable among us.
And how the principles of natural justice act as those essential, often unwritten guardrails, ensuring basic fairness in any legal process, hearing both sides, avoiding bias, giving reasons.
And then we landed squarely in the toughest challenge of all, the ultimate purpose of punishment. We've seen the theories.
Right. Deterrence seems to fail on certainty and swiftness. Prevention just contains the problem, it doesn't solve it. Reform, while hopeful, struggles with applicability and can feel unfair to victims.
Which brings us right back to that difficult retributive dilemma we discuss.
The system demands that we use the physical force of the state, that stark definition from Salmon, to try and correct a moral wrong.
Yes, and to restore some kind of equilibrium, the retributive idea requires us to quantify and deliver proportionate pain. An eye for an eye, conceptually at least.
But, and this seems like the core problem, if we accept that morality itself can be subjective, that fairness is debated, and that every individual's experience of suffering, of pain, is unique,
then how can a rational, rule-bound system like legal justice ever accurately determine and deliver that truly proportionate pain? We are fundamentally trying to quantify something that might be inherently unquantifiable.
which raises a final, maybe provocative thought for you, our listener, to consider. If the legal system's attempts at correction through deterrence, prevention, and even reform are all compromised in different ways by complexity, rigidity, the difficulty of implementation, the impossible task of measuring pain,
Is the ultimate goal of our state-run justice system truly about achieving noble correction or rehabilitation? Or perhaps, based on the mechanisms we've analyzed today, is its primary successful function, maybe its most achievable function, simply societal containment, managing risk rather than fixing wrongs?
The challenging question to end on. We hope this deep dive has provided you with some crucial frameworks, some useful tools to better navigate and evaluate the incredibly complex terrain of law and justice.
Thanks for joining us.
Until next time.